Hello, everyone. Welcome to Labor Standards and Social Legislations. The study of labor standards begins with concepts like labor law, social legislation, and principle of social justice. Now, let us define what are labor laws. Labor laws consist of statutes, regulations, and jurisprudence governing the relation between capital and labor by providing for certain standards of terms and conditions of employment, or providing a legal framework which these terms and conditions in the employment relationship may be negotiated, adjusted, and administered. So when you say labor laws, these are statutes passed by Congress providing for standards or rules in terms of terms and conditions of employment or and the employment relationship between the employer and the employee. So the law applicable in labor standards and negotiation is the Presidential Decree number 442 as amended, entitled A Decree Instituting a Labor Code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources development, and ensure industrial peace based on social justice. The Labor Code of the Philippines stands as the law governing employment practices and labor relations in the Philippines. It was enacted on Labor Day of 1974 by President Ferdinand Marcos in the exercise of his then extant legislative powers. It prescribes the rules for hiring and termination of private employees, the conditions of work, including maximum work hours and overtime, employee benefits such as holiday pay, 13th month pay, and retirement pay, and the guidelines in the organization and membership in labor unions as well as in collective bargaining. The Labor Code contains several provisions which are beneficial to labor. It prohibits termination from employment of private employees except for just or authorized causes, as prescribed in Article 282 to 284 of the Code. The right to trade union is expressly recognized as, as is the right of a union to insist on a closed shop. So there are many provisions in the Labor Code or in the Presidential Decree number 442 that afford protection to labor, promote employment and human resources development, and to ensure industrial peace based on social justice. So, what are social legislations? Social legislations include laws that provide protection or benefits to society or segments thereof in furtherance of social justice. It is broader as a concept and it includes labor legislations. Examples of social legislations are CARP and agrarian laws, SSS, PhilHealth, Pag-ibig, labor laws, paternity leave, Solo Parent Act, etc. So, what is social justice? Social justice means, or generally means, that the legislation must be in furtherance of the general welfare of the people. So, that is what we mean by social justice. That's why we have social legislations like SSS, PhilHealth, and Pag-ibig. Because these social legislations are made in order to protect the right of the general public. Now, kinds of labor legislation. So we have two kinds of labor legislations. One is labor standards and the other one is labor relations. And our subject matter for this term is about labor standards. So what is labor standards? Labor standards set out minimum terms, conditions, and benefits of employment that employers must provide or comply with and to which employees are entitled as a matter of legal right. So, when you say labor standards, this contains all the minimum terms and conditions of employment. For example, the hours of work. If you can notice that all establishment, particularly private establishments, cannot compel their employees to render overtime work because the hours of work that is allowed for the employers to require the employees to be present at work is should only be for a period or for an hour of 8 hours. So, if, for example, the employer will require its employees to report for work beyond 8 hours, then the employer is required by law to pay an overtime pay because based on the minimum term set by the labor standards law, employees should only serve for 8 hours a day, which is equivalent to a 1 day salary. So beyond that period of time, the employer cannot compel the employee to report for work. Otherwise, the employer will be made liable to pay for overtime pay. Another example of labor standards is the payment of holiday pay. So if you can notice, if you will render service on a holiday pay, say for example, a regular holiday, your salary for that day will be doubled. The basis for doubling the salary of an employee who renders service on a holiday, on a regular holiday, comes from the labor standards law. So, meaning to say, all the benefits, the terms, and conditions of your employment are governed by the labor standards law. It means that the employers cannot pay you a salary below the minimum wage, or the employer cannot set a term or condition of employment that is contrary to the labor standards law. So in every contract of employment, the employer or the employer should take into consideration the minimum terms, conditions, and benefits of employment provided for under the labor standards law. Otherwise, there would be a violation of the rights of the employees under this law. And even if the employer will not include in the employment contract the minimum terms, conditions, and benefits of employment under the labor standards law, these terms, conditions, and employment and benefits are deemed to have been written in every employment contract, and therefore the employer cannot say that they did not agree with such terms and conditions because according to the law, these minimum terms, conditions, and benefits of employment are deemed written in every employment contract, and therefore the employees are entitled to these rights as a matter of legal right. Now, when you say labor relations, this defines the status, rights, duties, and the institutional mechanisms that govern the individual and collective interaction of employers or their representatives. So, labor relations is covered by the subject labor relations and negotiations, which you can later enroll or take in the later term. So for now, we will not discuss about labor relations. We will focus on our subject matter, which is labor standards and social legislations. Now let's go to Article 4 of the Labor Code, which provides that all doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor. So what does this article mean? This article means that if there are vagueness in the labor code or in the laws implementing the labor code, such vagueness will be resolved in favor of labor. Or if there are vagueness in the employment contracts between the employer and the employee, then such vagueness will be resolved in favor of labor. So in Acuna versus CA 489 SCRA 658, the Supreme Court ruled that it is a time-honored rule that in controversies between a worker and his employer, doubts reasonably arising from the evidence or in the interpretation of agreements and writing should be resolved in the worker's favor. The policy is to extend the applicability of the decree to a greater number of employees who can avail of the benefits under the law, which is in consonance with the avowed policy of the state to give maximum aid and protection to labor. So for this topic, I will assign to you cases for research and study. First one is the Continental Steel Manufacturing Corporation versus Honorable Accredited Voluntary Arbitrator Alan S. Montaño and nagkakaisang magagawa ng Centro Steel Corporation, Solidarity of Unions in the Philippines for Empowerment and Reforms. GR number 182836, October 13, 2009. The second one is Jorizaldi Uy versus Centro Ceramica Corporation and our Ramonita YC and Milagros U. Garcia GR number 174631, October 19, 2011. And Cebu Metal Corporation versus Saliling 501 SCRA 61. In order to successfully research for these cases, make sure to type the GR number of each particular case. For example, in Continental Steel Manufacturing Corporation, the GR number is 182836 so that you can easily find this particular case. But for Cebu Metal Corporation versus Saliling, since it does not have a GR number, you may use the reference 501 SCRA 61 in order to successfully search for this particular case. Now, these cases were assigned to you on Quipper. So kindly visit your Quipper and follow the guidelines set forth therein. So that's it for this video and see you next meeting. Thank you and goodbye.